So my family or my children have been subjected to like a child protection plan by the local authorities, and that's due to their concerns about radicalisation and extremist belief. The child protection plan is very intrusive, so social services have to visit the family, the social worker has to visit the family and see the children every 7 to 10 days. I have to have regular meetings with all the multi-agencies that are involved with the children, and that involves speaking to and engaging with the counter-terrorism police officers, because they were the ones that triggered off this case of radicalisation. So they were the ones that presented this concern to the children's services. From my experience, I found the social services very ignorant in how they've dealt with my case. Looking at the facts ahead of them, i.e. the work that they've carried out with my family, the direct work they've done with the children, speak to them in my presence, alone with them, visiting my home, looking at the children's bedrooms, looking at the kind of books my children read, the DVDs that the children watch, the food my children eat. I have to, in order for me to safeguard the children, I must work with either a prevent officer or an interventionist provider who they allegedly say is independent from any kind of security services. However, they must be somebody which is Home Office approved. When I refused to work with an interventionist and when I refused to work with Prevent, this is when the matters became quite serious. So there was a lot of threatening languages used, telling me that this case will go into court proceedings, which is where I am right now with my case, that they cannot erase, even though they had no concerns from the 12 months of direct work they've done with the family, even though there are no concerns, what I was told is that the social worker, who I had a very good rapport with for the past 12 months, even though she hasn't seen any indication that my children have been radicalised, because I haven't worked with Prevent, which is a voluntary part of the plan, that has always remained voluntary from when the CP plan began till now, that they can't sort of deplan my family. Most importantly, what has been very, very effective for my case is the EIG report, the Extremism Risk Guidance 22 report. That has really kind of thrown over a lot of issues that the children's services have tried to push on me. So the brothers at Cage have attended meetings with my solicitor, giving them a bit of preparation work on how to incorporate the EIG findings into my case, and giving me a solid basis of why I've declined to work and engage with the Prevent strategy or even an independent IP. I am looking forward to going to court, because this is the only way I feel that I can actually remove the local authorities from trying to coerce my family into doing something that we don't want to, or we don't even have to by legal law, because Prevent is not something that is obligatory upon any family to work with. So that's where I am now with my case.